Well, more on that story now. Professor Hugo Pienaar, an employment expert and director at legal firm Cliff Decker Hofmeyer, joins us now to unpack the ongoing labor dispute over a 2015 amendment to the Labor Relations Act. It's a complex case, but how does it affect, firstly, the worker in South Africa, and how does it affect the labor broking companies?
Yeah, well, you will recall, Matteo, it started with a call for a ban on labor brokers. That was the initial call, but of course people must have realized that that would be unconstitutional, and hence the introduction of the legislation at the time. And 1 April 2015 it came into effect, and it brought into case further protection for these vulnerable type of employees. And when I refer to the vulnerable category of employees, those would be the employees employed for longer than 3 months and earning below the threshold of approximately 205k per annum. It's roughly, I think you indicated to me, 17,000 per month. Yeah. And that protection was then introduced. And the purpose of that protection was, of course, mainly to protect these employees. It did not deal with the banning or unbanning of labor brokers. It at best restricted the movement of labor brokers and their participation in the market. So what the legislator did, it said, I need to protect these people, and I will do it in one of 4 ways, and I'm giving you a simplified version. First of all, I'll extend joint and several liability. In other words, if the labor broker had to dismiss or were to dismiss an employee, that employee could then sue either the labor broker or the client, and there's a joint and several liability. And that could apply to dismissals, unfair labor practices, automatic unfair labor practice, and the like. So there was an extended joint and several liability. That was the first part of the protection. The second part was to provide for equal treatment. In other words, the labor broker employees would, after 3 months, those under the threshold, be treated equally to employees of the client doing the same or similar work. You will have a similar equal pay clause under the employment equity clause, although it's slightly wider.
And how does this affect then the dual employer system and the sole employer system? Yeah. Firstly, tell us what the difference is between the two and how it affects both parties.
Yeah. Well, it brings you to there's a third point of protection, and that is the permanent employment after 3 months. But the clause that caused a controversy was the one that said after 3 months the client is deemed to be the employer. And of course, what does that mean? Does that mean that the labor broker disappears from the scene, as the labor appeal court suggested? Or does it mean there's a dual employer test application where both the labor broker remains on the scene and the client as dual employers, as was ruled in the labor court case? But of course the Labor Appeal Court overturned that, and it's that case that's now before the Constitutional Court, and that was argued today. So it's essentially, is the labor broker anywhere to be seen after 3 months, or has it become redundant, or will it still play a role after 3 months? The Labor Appeal Court said that the client becomes a statutory employer. But of course the difficulty with that argument is that if the argument is that the labor broker disappears from the scene, there's no need for a joint and several liability clause anymore. That clause becomes redundant.
Falls away.
Yeah, and the same with the equal treatment clause, because if the employee is employed by the client, then the employee is protected by the equal treatment clause, or simply by the equal pay clause.
And how does that affect, of course, things like the accrual of leave days and, you know, how someone is paid, and pensions as well? Because if the labor broker falls away, then what happens to some of the things that you got while you were with him?
Yeah, you see, and that is the difficulty with this deeming provision. It does not say that they transferred. There is provision in the law for transfer of employees from an old employer to a new employer, and then there's provision for the transfer of leave, severance provisions, there's provision for transfer of pension fund monies, and all of that. In this case, you don't have that. And of course, just on that point, internationally, there's no suggestion anywhere in terms of international law, whether European treaties or otherwise, that employees are actually transferred. So the labor broker remains on the scene. What will happen in this case is that there will be, if the Labor Appeal Court's decision is upheld, is that there must be some sort of form of transfer to the client And then the question is who would be held liable for the outstanding leave, because there's no transfer provision.
And as it stands now, very quickly, is this a winnable case for NUMSA?
I think the judgment can go either way, but of course it will have long-term implications for the creation of employment in our country, because we know locally and internationally in the flexi environment, that's where you have growth of employment and we create more employment. We've seen since the introduction of this legislation, and there are statistics to suggest that 45% of people in this industry have already lost their job. Unfortunately, only 20% were effectively transferred to the client because of them losing the incentive of having a labour broker.
We'll see how that one plays out in the Constitutional Court. That was Professor Hugo Pienaar.